unworkable.
The states are recognizing that.
Some of them are, Mr. Justice. Professor Camisard's research indicates that 37 states now provide counsel for poor people in all felony trials. 8 others frequently do so as a matter of practice, and 5 make no regular provision for counsel except in capital cases. But I do not agree with any implication in your question that this movement by the states to act themselves argues against the step forward now by the Supreme Court. I do believe that the growing acceptance of right to counsel by the states makes a reinterpretation of the Constitution easier. I see my time is almost up, so I will try to sum up. I believe this case dramatically illustrates that you cannot have a fair trial without counsel. Under our adversary system of justice, how can our civilized nation pretend that there is a fair trial without the counsel for the prosecution doing all he can within the limits of decency and the counsel for the defense doing his best within the same limits? And from this clash, the truth will emerge. I think there is a tendency to forget what happens to these poor, miserable, indigent people in these strange and awesome surroundings. Sometimes in this court, there is a tendency to forget what happens downstairs. I was reminded the other night as I pondered this case of Clarence Darrow when he was prosecuted for trying to fix a jury. The first thing he realized was that he needed a lawyer. He, one of this country's great criminal lawyers.
Mr. Fortas, what are the limits of what you're asking? Now, at what stage of a criminal case must a lawyer be supplied? And in what kinds of cases?
Do we have to pass on that?
No, sir, not at this time, but I will give my opinion anyway. A lawyer should be provided at least from the first arraignment of the prisoner through his trial and appeal. And this right should apply in all but petty offenses.
What about traffic violations?
Even for traffic offenders. I know that sounds strange, but it would work. Only an occasional oddball would ask, and it would be very easy to say to him, "Yes, sir, go right down the hall to that door. That's the public defender's office. They'll see you." Thank you, Mr. Chief Justice.
Mr. Jacob.
Mr. Chief Justice, may it please the court. Clarence Earl Gideon had a fair trial. The trial transcript shows that he took an active part in his own defense and that he possessed much skill and facility in questioning witnesses. Also, his previous record of 4 felony arrests indicates that he was not wholly unfamiliar with criminal trial procedure. Judge McCrary, who tried the case, says, and I quote, that it is his opinion that Gideon had both the mental capacity and the experience in the courtroom at previous trials to adequately conduct his defense. He did as well as most lawyers could have done in handling his case, unquote. We have been asked to discuss today whether this court's holding in Betts versus Brady should be overruled or modified. We say that it should not, for several reasons. First, there is no historical basis for requiring states to automatically appoint counsel in all cases. Next, the rule in Betts versus Brady provides a clear and consistent standard for determination of the right to counsel. There are special circumstances that should be considered, such as the prisoner's illiteracy or youth.
How do you know what the special circumstances are?
Every time this court decides a case, we know another special circumstance.
Well, in recent years, in 4 cases, I think, we have reversed cases from your state every time you said defendants weren't entitled to counsel because of special circumstances.
We prefer case-by-case adjudication. It may not be precise, but we prefer it because it gives the state some freedom in devising its own rules of criminal procedure. This court has never laid down any fixed rules on the right to counsel.
What about the Scottsboro case? Doesn't that lay down a rule that lawyers are required in capital cases?
That was decided on the circumstances.
Perhaps so. But subsequent cases have made clear that there is a fixed rule for capital cases. There's no point in your arguing that.
What historical support have you found for the distinction between capital and non-capital cases?
Your Honor, I can't think of any.
I can't either. That's why I asked.
Well, there is a practical distinction between capital and non-capital case. You want to draw the line somewhere. Everyone is fearful of being put to death.
Maybe they're fearful of spending years in the penitentiary, too.
I would like to restate one of our basic contentions. When special circumstances warrant, this court can order states to provide lawyers. But by imposing an inflexible rule that every defendant is entitled to a lawyer in every case, we feel that this court would be intruding into an area historically reserved to the state. It would stifle state experimentation. For example, a state might eliminate prosecutors as well as defense counsel and leave the whole trial to a judge.
Don't go too far now.
Look, Gideon's not a lawyer, but you say he's capable of representing himself. Do you also think he should be allowed to represent other defendants?
If a defendant asks for him, I'm sure a judge wouldn't object.
Well, the local bar association might.
I hope that this court will consider the consequences of overruling Betts versus Brady. Grave consequences as I see them. The new doctrine of giving everyone a lawyer every time he asks for it would necessarily extend to the most trivial cases, creating a tremendous burden for the taxpayer. The next thing you know, indigents would also be demanding other free services, psychiatrists, expert witnesses, and so forth. In effect, this court would be requiring the state to adopt socialism or a welfare program. Also, please consider this. Of the 7,800 convicts now in Florida prisons, more than 5,000 were tried without counsel and might be eligible for release if this court overrules Betts versus Brady. If this court does reverse, we implore it to find some way to make it not retroactive. We have followed Betts in good faith.
Are any of those 5,000 prisoners in Florida illiterate?
Your Honor, I have no way of knowing.
But what do you think?
Yes, I don't know, but I suppose some of them are illiterate.
This court has ruled that an illiterate defendant is entitled to counsel, even under Betts and Brady. Illiteracy is a special circumstance. Any illiterate among those 5,000 has been deprived of his constitutional rights. Mr. Fortas, do you wish to say anything in rebuttal?
Mr. Chief Justice, in 1942, when Betts versus Brady was decided, this country was at war with Hitler Germany. Benjamin V. Cohn, the noted New Deal lawyer, and Irwin N. Griswold, then professor and later dean of the Harvard Law School, were referring to that when they sent this letter criticizing the Betts decision to the New York Times. I quote, "The decision in Betts versus Brady comes at a singularly